All right. So let me just say this. The way I remember the trial is that she was coming out of the shower. She was in a towel. The boyfriend had a gun. His mother had bought him as a Christmas present laser pointers that had the Christmas colors. He pointed his gun at her. It had a green laser on it. His brother tells her, "Hey, are you going to let him do that to you?" And she picks up a gun off the dresser. That's the way I remember the facts. There is nothing about a clip being taken out of the gun. She sees a clip out of the gun. That's the way I remember the trial.
Okay, Judge, and I respectfully want to correct you with that, and I'm pretty sure of that. The argument was that the clip was taken out of the gun. Even in closing argument, I argued that as one of the points as to why it is she did not believe that the gun could fire, because she did not believe that there were actually bullets in the gun because the clip was out of the gun. I probably spent 5 to 10 minutes arguing that point alone. So the clip was out of the gun, which is what we presented as the evidence in the case. And even after the trial, when talking to the jury, a lot of them understood that they believed that the clip was out of the gun. So that wasn't what the case hinged upon, but we did present evidence at the time that the clip was out of the gun. And Your Honor, you are correct that she was coming out of the shower. She did have a towel on because she was planning on leaving. They were planning on going out, but the boyfriend, again, was playing with the gun. So this is a totally different gun. I understand that the state tried to put on evidence, or they put on some evidence, I believe, that the gun had been on the dresser at some point because and you called him the brother, I think he was a cousin, he was stating that he never brought the gun into the room. But we put on evidence that he did, in fact, bring the gun into the room. Talking to the jury after trial, they believe that too. Now, obviously, the jury found her guilty. We understand that. I did talk with the jury after the trial. The jury placed her on probation, did not sentence her to prison. And the overall thing of it for them was that obviously, if you have a gun, you shouldn't play with a gun. That's just, and we all understand that. She understands that here today. Nobody's fighting that particular point that you should not play with a gun. But it's important for us to state that the person who was shot and killed, unfortunately, was pointing a gun at her and had been pointing a gun at her. And it wasn't until the cousin introduced his gun and gave it to her or presented it to her, put it there in front of her and told her, are you gonna let him do you like that? And she picked up the gun. There's no doubt whatsoever that she intentionally took the gun in her hand. So we're not trying to say that somehow the gun fell into her hand and she had, nothing else to do but to pick it up and shoot her boyfriend. She was not attempting to shoot him. In fact, after he was shot, she immediately rushed over to help him. She did everything she possibly could do to try to save his life. She was hysterical. When the police arrived, the deceased mother tried to say that Miss Castillo had not, in fact, shot her son, that some robbers came in the house and had shot the son. And Miss Castillo said to the police at that point, "No, that's not true. I shot him." And so the police did not have to worry about trying to investigate whether or not robbers came in the house and shot the young man, which is the story that the family was presenting to tell the police at that time. She took full responsibility at that particular time for being the one that, in fact, had shot him. It was not presented as a murder case. It was presented as a manslaughter case because of the reckless nature of this particular incident. After the young man was shot, again, we say that Miss Castillo was hysterical. If you recall, she was sitting in the yard. She kept calling his name. When she went to the police station, she told the truth. She was forthcoming. She's always been forthcoming. The jury did, in fact, again, find her guilty of the offense. They found her guilty of the offense. But again, I talked with a lot of jurors, which is my normal course after these trials. And many of them believe that this was a very unfortunate incident, that she had no intention of shooting him, that it was an accident. However, they felt because there was a gun involved and there was some degree of playing with the gun on her part, that she should have anticipated that something like this should happen. But they also felt it necessary that she be placed on probation. After the trial, the court, Your Honor, in talking with her, I remember or recall you intimating that you would be following this case very closely, making sure that she abided by the terms and conditions of her probation, and that if, in fact, there were any infractions, that could result in her going to prison. We told you at that time that we believed that she was a good young lady, that she would do the right thing, that we did not believe that there was going to be any issue with regard to that. And you intimated that, well, if not, the possibility always is that she might be early term. Of course, the court would not state at that particular point that would be something that would happen, but it gave her something to strive for. It gave her something for which to have hope. And so she has complied with the terms and conditions of her probation. She is up to date on all monies. She's paid all monies. She's done all courses that have been presented for her to do, including a parenting class. She's done all of her community service hours, 200 hours of community service. She is gainfully employed. She's raising her now 2 children. She had a son at that particular time. Her son is a straight A student in school, well-adjusted to school. She has done everything that this court has asked her to do. She is not putting this behind her because she loved the young man that was killed. That was her friend. And this has been devastating to her. And obviously, it's always devastating to the family. You can never get around that. And you would not try to get around that. But I believe that Ms. Castillo has presented herself well before this court. I don't think you've had any trouble out of her. And she's just tried to comply with everything she's supposed to do. I've kept in touch with her over the years and with her family over the years to see how she's been doing. Having another child, continuing to be employed, keeping up with her probation. I'll talk with her about it. And she says, yes, Mr. Marshall. Yes, Mr. Marshall. So I just think that she is a worthy candidate. She is a worthy candidate for early termination on this case. And I would ask that the court would consider terminating her probation.
All right. So the way the court remembers the facts of this case is, as I previously stated, and an expert was called to testify. And the questions that were being asked of the expert were whether or not dropping a gun, because that was part of the defense. The gun was dropped. The gun went off accidentally, and the gun hit at such an angle, a lucky angle, that killed the complainant. And then the expert testified, and I believe it was defense expert, testified that no, this gun would not go off if dropped accidentally. And there may have been some closing argument about then maybe she didn't know the clip was loaded or not loaded. State?
After the state, if I may.
Sure.
For argument or about the facts, Judge? Because you're the one with the facts.
No. I'll hear your argument.
Yes, Judge. At this point, a jury did, hear all the facts, and they heard them as you did, Judge, and they still returned a verdict of guilty. And as we know, they have the option of assessing as low as 2 years if they were going to give probation. The jury chose, after hearing all of the facts and hearing all of the argument, the jury chose to give her 10 years, which seems to be deserved for probation, Your Honor. It does seem like this was a probation-worthy case, but they still chose to assess the maximum amount of probation being 10 years. And we would just ask that the state follow that, and that the judge follow that. Because then at the end of the day, a young man lost his life. And as we both know from other, expert testimony, just because there's not a clip doesn't mean that the gun's not loaded. And first rule of gun safety, you don't point a gun at somebody unless you intend to fire it.
And if I may, Your Honor, and that's just not the facts of this particular case. I believe the fact in this case, which was undisputed, that she had never personally handled a gun before. Also, when talking about whether the gun fell to the ground or not, I don't believe our argument was that she dropped the gun Our argument was that because of the type of gun it was a gun that had been known to have a quick trigger. And so questions were elicited as to whether or not if the gun was dropped, so on and so forth, would it fire? And our expert, which we knew what he was already going to say, basically said with respect to that gun, no. But what we were really getting to was the nature of the quick trigger in this particular case, because there was some issue as to whether or not this gun fired with a quick trigger. And so when having the gun in her hand, is she intending on firing the weapon, shooting her boyfriend, so on and so forth? No to that. But we were, eliciting questions as to whether or not, or answers as to whether or not the gun had a quick trigger. And so our expert witness said he did not believe, in his expert opinion, that particular weapon, although that style of weapon was known to have had a quick trigger, he didn't believe that particular one did, because he was not able to test that gun until, I believe, the day of trial. I think the day he testified was the day that he was able to look at that gun on the stand, actually, is when he was able to do that. So with that having been said, again, the jury did find Ms. Castillo guilty. Again, I talked with the jurors after the trial. And in fact, I believe we even argued, or at least let them know that, and I think I even requested at some point that they give her the 10 years of probation, right? And with the idea that if she complied with probation, that she might be early termed. And I talked with some of the jurors about that after the trial, and they understood that if she was in compliance, that, the court had the discretion of early terminating her from probation. So I don't even think that all of the jurors, really thought it necessary that she do all of the 10 years. What they thought was really most important was, one, that she understands the nature of what had occurred in this particular case and how serious it was. Two, that she responds as one, not only with words coming before the court and saying that she's going to do the right thing and be the right kind of person, but that her actions would actually follow. And her actions have. She's done everything the court has asked her to do. She's paid everything. She's done all of her community service hours. She's done all of the classes. She has a very good rapport with her probation officer. I believe the probation officer, the one that, told her to come before the court and ask the court to terminate her early, if my memory serves me correct. So it's just one of those cases where, and I understand, I get it. I understand it's a manslaughter case. Somebody lost their life, and you know what? You just got to do the 10 years. Well,
no, actually, counsel, and I believe afterwards, both you and the state's attorney came before the court after this was all over and asked the court, hey, if we would have came for you on an open plea, do you remember that conversation?
And I believe you said that you would have given her deferred adjudication.
No, what I said was that if you all had come to me on an open plea, that I would have given her deferred, because these were two young children playing around with guns. That's what happened. Two young children playing around with guns. And I said their parents were allowing them to play house and play around with guns. And I would have given her deferred adjudication. But where we are now is she hasn't even done 5 years on probation yet. And in the big scheme of things, somebody is dead. I understand that she loved him. I do remember the facts of the case. I remember her being on the sidewalk when the police came, and she was telling them that she shot him. And the complainant's mother is saying she doesn't know what she's saying. She's in shock. Robbers came in. I remember that. So I want you to know that I remember all of this. I remember that you were very distraught because the person that you loved died, right? And I know you didn't mean to kill him. That's why it's a manslaughter case. And I know that part of the fault, and I don't like to pass blame around, but parents should not have allowed children to be playing with guns. And I remember listening to the testimony and thinking to myself, I didn't know laser pointers now come in Christmas colors, holiday colors. Why are people marketing holiday colors for people, and especially children. But my problem with this case in granting you early term is you haven't even done 5 years yet. This is from 2020. You need to at least have done half the time. And I know you can come forward at a third of the time, but at the end of the day, someone's dead. And I'm not trying to make you feel any worse than you already feel. But honestly, they're dead because you picked up a gun. Whether you knew it was loaded or not, you picked it up, you pointed at him, and you fired. So you should at least serve half the term before you come to the court asking for early term. You understand?
Yes.
All right. So at that point, I will strongly consider your motion for early termination. But now you've just been on since 2020. And I know sometimes people rush through conditions that are given to them. And I appreciate that because I want you to do it. You appear to be on the right track. You're doing what you need to do. But a third of the time and somebody's dead is not enough in this case. You understand?
Yes, ma'am.
So come back when there's 5 years. 21 CR 8557A, State of Texas versus Bridget Adams. Could I have parties announced for the record for the state?
Zach Dunn for the state, Your Honor.
Defense.
Joseph Appelt.
And are you Bridget Adams?
Yes, ma'am.
Going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision, and state's motion to supplement pending motion to enter adjudication of guilt and revoke community supervision. Did you review that document with your attorney? Did you understand it?
Yes. Yes, sir.
mean,
Yes,
did
ma'am.
you-
I'm sorry.
That's okay. Did you review it or no?
Yes, ma'am.
All right. Are you the same Bridget Adams who was placed on deferred adjudication in 2021 CR 557A for the offense of endangering a child on December 8th, 2021 for a period of 5 years? Is that you?
Yes, ma'am.
All right. State.
Your Honor. Violated condition number 5. In Bexar County, Texas, the defendant, Bridget Adams, did then and there fail to report to the supervision officer as directed for the months of June 2023, July 2023, and August 2023 in violation of condition number 5.
How do you plead to that? True or not true?
True.
And Your Honor, the state will waive and abandon the other conditions.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility, and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, ma'am.
Court will find violation of condition number 5 true. Is there a proposed agreement?
There is a proposed agreement, Your Honor.
And what are you requesting, state?
The proposal, Your Honor, would be revocation, adjudication of guilt, an affirmative finding, and essentially, if I have the days right that counsel had provided, it's 300 plus days of time served credit with potentially inpatient treatment, if that time would be counted, would almost equal the 2-year timeline for the state jail, Your Honor. So it's essentially revocation, adjudication of guilt, affirmative finding, and essentially a time served given the time that this individual has spent. That's the proposed agreement, if I'm stating everything correctly, counsel.
That's correct, Your Honor. And if I
An
may,
affirmative finding,
This is an endangering, Your Honor.
but that wasn't requested as a part of the plea bargain agreement.
Okay.
And I didn't find an affirmative finding of family violence beforehand. If you all are agreement to that there be an affirmative finding of family violence, of course, I will go with that.
we would prefer not, Judge.
That's absolutely fine, Your Honor. We're happy to waive and abandon.
All right.
And I wasn't part of the plea originally, Judge. I was not aware that that was not part of it. However, I think we're in agreement that it will not be a part of this.
That goes for the
agreed
state, Your Honor. Absolutely.
Okay.
And if I may, Your Honor,
Yes.
my information is that Ms. Adams has 336 actual days jail credit.
Mhm.
Did complete SafeP successfully at 286 days at SafeP. And we're asking for that total of 622 days being, for her to be given credit for the total of 622 that she has been in custody in one way, shape, form, or other, and to go along with our agreed recommendation and have this as a JSAT.
All right. So they're saying that I'm reading any objection to the court reading the court reporter, I'm sorry, the probation officer case review?
The court summary judge, no.
Okay. So it says here that she left the dorm and never returned. What's that about? Do you want to address that?
Yes.
Just 1 second. Can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
My name is Bridget Adams, ma'am.
All right, so why did you leave the dorm?
Yes, ma'am. At the time, I was in my addiction, and I left, and I went and got high. But may I say, ma'am, as of today, I've been clean of 8 months, and I also have a job waiting for me, and I will be staying with my mother and father if I get released.
The reason for the leaving of the dorm, Your Honor, was an outside influence with a person that she was involved with, who she was no longer involved with, is my understanding. It was been reported to me by Ms. Adams, and her successful sober time period of 8 months, as she reports to me, is because she was no longer with that person and does not associate with that person. That, and with the support of her mother, is where she is relying upon to remain sober. She has not picked up any new offenses either. And she does say she does have a job waiting for her through a friend of hers who is a manager at at Whataburger.
She hasn't really been successful on probation. And her sobriety for the 8 months, is that because she was in custody?
No, ma'am.
No, the time in custody was spent prior to her being picked up on this MTR, judge, is my understanding.
Okay, so I don't know if she was clean and sober or not. We're just going by what she's saying.
If I may, Judge.
Sure.
My mother can attest to it. If need be, I have not touched methamphetamines or anything in 8 months. I actually am engaged, and I am trying to settle down, and I'm trying to do better. Yes, I know I have not been very, what's the word?
Compliant.
Compliant. Yes, thank you. I know I haven't been very compliant, and yes, I know my actions do not show that I've been compliant, and I very much apologize because you have been gracious with me. But I am asking because I have been sober, and I do have a job waiting for me, and I do have a mother that is waiting for me to come home, and she is very ill right now.
All right, so here's the thing. I always tell people, don't play the illness card on me with the parents. And the reason why I say that is because, one, she doesn't need stress in her life. And you're not doing well on probation has caused her stress and contributed to exacerbating her illness. You understand?
Yes, ma'am.
So when you say you are engaged now, what does that mean?
I have a fiance at home, and he's also working, and he's been helping me stay sober. He's been sober for 5 years now, ma'am.
Okay. And did anybody know this?
State was unaware.
I'm not inclined to just let her skate on probation and get 2 years and have that be a judgment satisfied. So here are your choices. I'm giving you two choices.
Okay.
One, I can find you guilty and place you on regular probation. Or two, I'll give you the 2 years, but you're not getting credit for inpatient treatment time. So which do you prefer? And if I give you probation, according to their recommendation, you're going to state ISF. So I can revoke you, sentence you to 2 years. You're not getting credit for your inpatient time. You'll get credit for your jail time. Or I can place you on regular probation, which would be a felony conviction, and you're going to state ISF. Which do you prefer?
Maybe ask them how to visit judge so I can discuss with her.
Yes.
Yeah.
Who is here on Ray Abaye?
We are.
Good morning. How are you doing?
How are you?
All right. I see you survived Valentine.
It was uneventful. In fact, I spent yesterday evening at my house waiting for the alarm company to show up. So yeah.
So you were not on the 13th at midnight getting married?
No, I was.
Okay. All right. What is happening with this case?
Judge, this is a sentencing for today. You did a quick reset to get sort of a preliminary PSI done
Here we are.
because his mother had passed away and the mom's funeral is coming up on the 27th, although that might be being delayed a little bit, he tells me today.
All right. I was looking at his wrong file. I guess that's the case that's being taken in consideration.
Okay.
All right. Let me.
John Coons from Metrobia.
And are you Mr. Abaya?
Yes, ma'am.
You entered a plea of guilty on February 5th. According to the plea bargain agreement, the state is opposed to your application and they're taking in consideration 2024 CR 0986. And the court had the facts of the case and both parties agreed to make sure that the sentencing is heard as quickly as possible, that it would be a slimmed down PSI.
Yes.
So the PSI that I've received, counsel, have you had a chance to review it?
I have, Your Honor.
State, have you had a chance to review it?
I'm reviewing it now, Judge.
All right. Any objections, defense?
No objections.
All right. Defense, do you have any witnesses?
No, just my client a little bit.
All right. Do you want to call him?
Sure.
All right. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right. You can lower your hand, state your name for the record.
My name is Ray Obaya.
All right. Defense?
Thank you, Judge. Ray, unfortunately, as we've discussed with the judge, your mother recently passed away. Is that correct?
Yes.
How long ago was that?
She passed away about like 4 weeks ago.
And you were locked up at the time.
I know I was out there with her.
But you've been incarcerated more recently. Is that correct?
Yes.
Now, your mother's funeral is supposed to be on the 27th.
27th, yeah.
Is that, but you're telling me that it might be delayed a little bit?
Yeah, we're just trying to figure out what's going on.
What's going on with you?
Yeah, with me, yeah.
Okay, so your family is waiting to see what happens
Yeah.
today, but more than likely it's going to happen on the 27th?
Yes, ma'am.
Okay.
Yes, ma'am.
So, Ray, you and I were going through the PSI a little while ago, and I was pointing out your criminal history.
Yes.
And unfortunately, you have been arrested a lot.
Yeah.
And you have struggled with substance issues for a long time, haven't
Yes,
you?
sir.
How old were you when you started using drugs?
Like 13.
All right. And how old are you now?
38.
30?
38.
38. Okay. So you've struggled with it for about 25 years?
Yeah.
But more recently, you've been sober.
Yes.
How long ago were you able to kind of get away from drug life?
It's been like 2 years now.
All right. Now, if the judge is nice enough to put you on probation, are you willing to be tested every week?
Yes. Anything I can do to prove that I'm changing and I'm sober.
And if you did start testing positive for some reason, if you did relapse, you'd be willing to go to rehab if that's what the judge decided. Is that correct?
Yes, but I think like I'm good enough with myself that I know I won't be able to come. I won't come out there at all.
Now, Ray, where would you live if you got out of jail?
I'm with my mom's boyfriend, which is my father-in-law.
Or your stepdad?
My stepdad, yeah.
All right. And is that here in town?
Yes, sir.
Out by SeaWorld?
I see what.
And then do you have any plans to get employment?
Yeah, I already have something lined up down the road because I don't have a vehicle. So I could just walk there and walk back home.
So when you say down the road, you actually mean literally down the
Yeah.
street?
It's like about a block or two.
At a restaurant?
Yeah, restaurant.
Okay. Is there anything else you'd like to tell the judge about why you think you should be given probation?
Yeah, I just feel like now at this point in my life, I'm older already. I'm tired of going in and out of the system. I feel like I changed my ways, especially with the drugs and everything like that. And I feel confident in myself and to show everybody I can do better, and I feel I can do better.
Okay. I have nothing further, Judge.
Any questions?
Mr. Abaya, my name is Nate Wilkins. I'm one of the prosecutors here. So if I see something that you don't understand, just let me know and I'll try and rephrase it. So this is that PSI. Did you go over that with Mr.
Yes, we went over it.
Y'all talked about it a little bit. Okay.
All right. Make sure y'all not conversational because it's hard for the court reporter.
Yeah, sorry about that.
No
So
problem.
Diana's trying to type up everything I say, so I cut you off there. I'm sorry about that. But y'all, you and Mr. Kuntz looked this over, right?
Yes, we do.
And does this pretty accurately represent your criminal history here?
Yes, it is.
Okay. So do you remember being on deferred adjudication back in 2003 for this unauthorized use of a vehicle?
Oh, yes.
And it doesn't look like you were successful on that.
Yeah, that, like I was saying, like I still had my issue with drugs and everything like that. That's what I'm saying. Like now, the way I am, I feel like I'm confident. I'm changed, you know, and I can do it. Show the system that I can be better and do better.
Okay. So, and I guess that would be my question is, that's what you feel like is different this time than back
That's
then?
what I was telling Mr. Kuntz that I'm willing to do whatever y'all need me possible to prove to y'all that I can come out clean and I can show y'all I can be a changed man.
Okay.
If I do get probation, like I'm willing to work with the system. I mean, whatever situation it is, or to prove to y'all that I can do it.
And were you still having those same type of problems when this offense happened in August of 2023?
No, this was just when I was the first one that because I was taking care of my mother and it was like nobody was there, so my issue was to try to stay just to take care of her.
Okay. So you weren't having as many problems in August?
Yeah, I wasn't doing drugs or nothing like that. It was just the issue of like being there for a while. So my choice was that's why I made that decision.
Okay. Okay. I pass the witness room.
Any further questions?
No, Judge.
All right. May I ask a question?
Absolutely.
All right, Mr. Obaye, your criminal history is a lot. And it seems that you're committing the same type of offenses over and over.
Yeah.
So I'm trying to figure out what you have learned.
Well, the issue, like when I was saying, I just barely like had the issue with my mom. She would always tell me like, what's gonna happen to you when I'm like, what are you gonna do when I'm gone? And I never really thought that over until these past couple of years when I had been taking care of her, and I really saw what I was doing wrong and what my issue was. So that's why, like, for the past 2 years, I did come out clean for her, and I was doing right for her, and I did everything I can to stay with her. Like, I didn't work or nothing, but I was there with her, taking care of her to her stroke, her heart attack, and hospice. I was there. I was the one there taking care of her, and it made me think about what I've done in the past. So I feel like it made me a better man, knowing that I feel like I will be better off out there than in the system. Just to show you, like, I can be a better person. And that's the way I feel. Like, I know the issue back then was I was young and I was on drugs and I really didn't think about nobody else but the drugs. And seeing what, like, I lost my father, and then I lost my mother, and I have no parents. So I have my brothers and sisters, but they weren't there for me like the way my parents were. So now I have an obligation to show. And not to show him, but to prove to him like I can be a better person. Now that I lost my mom and my father, and I feel like the way I can do that is be clean, and I was clean, and I did everything I could to be there for like my family. And everybody usually comes to me like to support, like for taking care of somebody or being there to help somebody out, or anytime like there's an issue with the family, we always come together, and they're all like I'm the one they come to. So that's why I feel like in the past 2 years, I have changed, and I think I can do better. And that's why I was saying, like, I'm here to show the state, like, I can do better, and I feel I will do better. Whatever issue it is, like, to make it harder for me to show y'all, like, I can be clean, I will do it.
Okay. All right, Mr. Obaye, I want you to know that I took into consideration everything that you said to me, and I reviewed your criminal history. You're just not a good candidate, right? But I know that you've been working on things and you've been trying things. So I'm going to find you guilty, and I'll sentence you to 1 year in the state jail facility. I'm going to give you credit for any time served. I'm going to take in consideration 2024 CR 0986, and I'm going to request for you the therapeutic community. It doesn't increase the time that you're at the state jail facility, but if there's a drug issue you have, or if there's a mental health issue you have, or some type of trauma you have, they will be able to help you address that. So when you come out, you can continue on the track that you say you're on. You understand? All right.
Thank you, Judge.
You're welcome. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yeah, we saw, I think it was the last time we went through it.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do.
That's a cognitive track. I apologize.
Yes, no, I'm not inclined to let her continue on deferred because she was sent to felony drug court. And people say I should not explain, but I like to explain so you'll know where I'm coming from. And I'm just not saying no just to be saying no.
Yes.
All right. So you were sent to felony drug court. You left the dorm without permission. You absconded from felony drug court, and felony drug court was continuing to try to get in contact with you to get you to come in. You did not. And you had a prior motion to revoke with this court. So this is not your first motion to revoke. So I'm not going to continue on deferred. So it's either guilty and you will be placed on probation, or either it's guilty and you will be given the 2 years, but not credit for inpatient time.
What we discussed previously. So
Yeah.
you said you wanted the ISF.
ISF, ma'am.
All right. Are you waiving your right to appeal?
Yes.
All right. The court then will find you guilty. The court will sentence you to 2 years in the state jail facility, suspended and probated for 5 years. I don't know if she's going to qualify for state ISF probation because last time there was an issue with mental health.
If I read it correctly, there's something with the DDRF that she did not qualify for DDRF.
All right.
That's my epilepsy.
All right. I'll alter them in conditions to include state ISF or felony drug court. And she's to remain in custody. There's going to be regular reporting by Zoom or in person. Random, regular UAs. Field visits. 1 time per month for 4 months. And then at probation's discretion. Proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. And there's to be no unsupervised contact with minors. I'm not going to ask her to complete parenting classes again if she's already completed it. I'm not going to ask her to do community service hours if she's already completed it. But whatever she has not completed when she was on deferred adjudication, she'll need to complete it probation. And then, are you receiving SSI? I have a note here where previously I said proof of SSI.
I was working on fighting for it, ma'am.
Okay. All right. So there's going to be, you're going to have to be employed. Do you understand?
Yes, ma'am.
Probation. Is there anything else? All right. There's going to be 200 hours of community service restitution. Okay.
Yeah.
Anything else, probation?
No, Judge.
Is there anything else you need from the court in order to be successful?
Just support.
Okay.
You know,
All right.
I'm trying to stay sober. I'm trying to do the right thing this time. So, and like I said, I've been 8 months sober, and I just want to continue because the person that my attorney, Mr. John, was talking about, he is actually recently deceased. He committed suicide. So I am.
Is that your fiance or someone else?
He was my boyfriend at the time, the influencer.
Mm-hmm.
He just recently committed suicide and he passed away on January 21st. So I have no contact.
All right, so here's the thing. If there's an issue, you don't just abscond, you're on probation,
Yes, ma'am.
right? If anything were to happen and you were to get another motion to revoke, you're looking at potentially 2 years at the state jail facility. And I'm sure your attorney told you state jail time is day for day time. You understand?
Yes, ma'am.
If there is something and you feel like probation is not addressing it, you can always come back to the court. And when felony drug court comes to interview you, you need to apologize to them and ask to be placed back in their program. That's a great program. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's what I understand. Usually people will gravitate towards people who are in treatment. Felony drug court will tell you that's not a good idea. You understand?
Yes, ma'am.
All right, good luck to you. Thank you, counsel.
Thank you, Judge.
Jesus Trevino. Okay.
I'm sorry, sir. Go away. All right. Yes, Judge, on Jesus Trevino, I filed a motion for competency
Okay.
back in January,
Okay.
and we're still waiting for that.
All right, Norma, can you make sure that that's on the radar for Judge Carruthers' court?
Yeah, I looked it up and I saw the filing.
And then if it's in there, we will
Yeah, I
call her back on the 28th, since she's already going to be here with her other client.
on the March 20th.
Yes.
Correct. Okay. Yeah, I filed it January 23rd, Judge.
And Mr. Trevino,
Yes,
you were late for court. Do not be late for court again. You understand?
okay. Oh,
Apparently, he's been in the hospital. He's on his way back to the hospital, Judge.
All right. What are you in the hospital for?
somebody hit and run me and I have a broken collarbone.
Oh, well, you shouldn't have came to court.
Yeah.
All you had to do was let your attorney know and she would have given me documentation. We will get you back to the
They
hospital.
have to pop it back in.
Oh, okay. Norma?
Yeah,
All right, we'll call you back for March 28th.
Okay, thank you. All right, go, go, go.
Thank you, ma'am.
March 20th.
Oh, he needs to sign the form.
Oh, you need to
Yes.
sign the phone. Don't forget.
Jesse Arriaga. Who's the attorney?
Okay.
All right. Yes, what is happening with this case?
Judge, we were on Monday's docket, but I was in another county, so I don't want to recall it. It was the first sitting, I believe, on Monday.
Yes.
We've gotten the discovery, but we also need to set an interview to meet an appointment to watch the forensic interview. That's our next step, and then we'll be getting ready for trial.
All right, Ms. Ferguson, on Jesse Arriaga, if I can have a 30-day reset, counsel, you need to have watched the video by that time. And you have tendered an offer?
No, not yet, Your Honor.
Okay. So when we come back on this date, states you'll need to be prepared to tender an offer.
Okay, Judge. The judge, I can do March 21st.
March 21st?
That's fine, Judge.
All right. Once you sign the reset form, you're excused. Thank you. Esther Diaz. Who's the attorney? Hi. Come down.
Judge.
Morning. Court is calling 2023 CR 8835, State of Texas versus Esther Marie Ariana Diaz. Could I have parties announced for the record for the state
Daniel Escobar from the state of Texas.
defense?
Julie Pollock.
And are you Ms. Diaz?
Yes, ma'am.
Counsel, have you received all the discovery? Did you review it with your client?
Yes, ma'am.
Court will find that the state is in compliance with discovery. Is there an application for this case?
Yes, ma'am. Deferred adjudication.
Okay. Ms. Diaz, I'm showing you what's entitled application for deferred adjudication. Did you review that with your attorney? Did you understand it? Did you
Yes,
sign
ma'am.
it?
Yes, ma'am.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are.
Ms. Diaz, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of harassment of a public servant? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe so.
Ms. Diaz, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, there's a $200 fine to be probated. State recommends deferred adjudication and anger management. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney?
Yes,
Did you
Your Honor.
understand it?
Yes, Your Honor.
Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, ma'am.
Next, I'm showing you outside the agreement. State is requesting that your community supervision be for a term of 2 years. There'll be a TAP evaluation and 50 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State officer exhibit 1 in all factors.
No objection.
All right, you may continue to confer. Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
Yes, ma'am.
All right. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Well, we would just ask that you follow the recommendation of the prosecutor in this case.
All right. How old are you?
31.
And who is Carlos Gutierrez?
My older son.
And how old is he?
He's 17.
And are you employed?
Not at the moment.
When's the last time you had employment?
It's been like a year.
How many children do you have?
No, I'm lying. I'm sorry, ma'am. I do Uber and I DoorDash and I have 5 kids.
All right. And what are your children's ages?
My older son is 17, which is Carlos. My daughter, she's 15. My other son, he's 13. My daughter, she's 11. And my youngest is 4.
And are you currently pregnant?
Yes, ma'am.
Who helps you with the children?
My husband.
So that's who has the children right now?
Yes.
All right. So why are you spitting on a police officer?
It was just, I was angry that day because I was looking for my son and I didn't know that he was in a stolo, which is a stolen vehicle. And I was angry. And when I crossed the street, the officer had waved me down, like, stop, like, but I was scared because my son has mental illness. And I was scared that he might make like a wrong move and then they might end up shooting him.
So how did you think spitting on an officer was going to
Well,
alleviate the situation?
They had jumped on me first. Like they both, and I was more angry because I don't know if that time I was still pregnant or if I already had a miscarriage before I got pregnant, this pregnancy. And it was just out of like anger, I guess I did it. Because when I was trying to tell them no, what I was trying to do, they still had just one put their like knee in my back and holding my hand. The other was just digging me more in the ground. So it made me mad because I was trying to like stop my son from. But either way, he ended up getting away.
Has Child Protective Services ever been involved in your life?
Once in 2012.
And why were they involved?
Because I had came out dirty with marijuana from secondhand smoke from my daughter.
Which
But,
daughter?
Ashley.
And how old is she?
She's 11.
So you're saying your 11-year-old was smoking marijuana?
No, I'm not saying that.
Oh, you're saying she was born testing positive for marijuana?
Yes, ma'am. But I had did my parenting classes and then whatever else they needed, I passed it.
All right. And are your parents involved in your life at all?
My mom kind of, but my dad, he's in a hospital in critical condition. Like he passed away, but they revived him. So right now he's still in the hospital.
Okay. All right. Is there anything else I need to know about you that I have not asked?
No, ma'am.
All right. This is what the court is going to do. The court is going to sentence you to 3 years deferred adjudication. There's a $200 fine that will be probated. Anger management. $100 hours of community service restitution. I'm going to order parenting classes.
Yes, ma'am.
When's the last time you used drugs?
Well, I had ended up relapsing when I found out about my dad. It was like 2 weeks ago.
2 weeks. And what did you use?
I used meth.
Okay.
Meth.
You know that's not good to use meth and you're pregnant.
Yes, I know. And that was my biggest mistake. And I'm not doing that no more.
All right. I'm going to order a referral to felony drug court and TAP evaluation. That's going to be in custody. You need to let felony drug court know that you have a drug problem and you need to be in their program. Do you understand?
Yes, ma'am.
And if felony drug court doesn't accept her, follow all TAP recommendations. If TAP recommends inpatient treatment, then she's going into inpatient treatment. There's going to be proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors until you're in treatment. There's going to be 90 sober meetings in 90 days. Regular reporting by Zoom or in person? Random, regular UAs, field visits, one time per month until further notice. Probation, is there anything else? If she completes parenting classes, the community service hours will be deemed satisfied. But you must complete parenting classes. Do you understand?
Yes, ma'am.
You have a question about anything?
I don't need any treatment like for drugs. Like I could show you that I don't need treatment.
Okay, let me just tell you why I think you need treatment for drugs. And I'm going to ask you some questions, right? And I'm not trying to trap you. I just want to ask you some questions. So, when you used meth, did you know you were pregnant?
Yes.
Do you love your unborn child?
Yes.
So, what you did was you chose drugs over the health of your unborn child. That tells me that you have a drug problem. Because otherwise, you know what you would have said? I really want to use, but I'm choosing my baby over drugs. You chose drugs over your child, which says you have a drug problem. Or either you don't love your child.
Right.
So that's why. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we're going to go off the record. In this court, in order to be successful at probation, communication is key. If you feel like there's an issue you have, let probation know. If you feel like they're not addressing it, you can always come back to the court. Do you understand?
Yeah, okay. Yes,
And it would probably be in your best interest to be in felony drug court. Felony drug court is a hard program, but at least that's somebody that you can pick up the phone and call 24/7 if you're thinking about using. You understand?
Yes, Your Honor.
All right. Do you need anything else from the court?
No, ma'am.
Okay.
Judge, may
Yes.
I address something?
Yes.
How long does it usually take for drug court to interview them?
Well, because we're at the end of the week, she'll probably be interviewed next week. They're quicker than the TAP evaluation.
I told her she was going to get out today, that she would likely follow the plea bargain. Her father's on life support.
Mhm.
And
She's,
I don't know how
I'm
much-
sorry, I understand that, but you're not getting out today. I will, if there's no objection from you, counsel, I'll send an email to felony drug court to see if perhaps they can squeeze her in
That would be
sooner than
great.
next week. I'll do that.
That would be great.
Okay. All right. So I'll send that now.
And would you consider lowering the supervisory fees to the minimum?
No, because I've already probated the fine. What are the court costs in this, please? It's a third degree. And it's harassment of a public servant.
$450.
All right. We're back on the record. The court costs in this case are $450. Will you be able to pay that in installments or no?
In installments, yes.
All right. Thank you.
The exchange centers on a defense attorney arguing for early termination of probation by clarifying the facts of a manslaughter case and emphasizing the defendant's conduct since conviction. The attorney disputes the judge's recollection about key details, such as whether the gun's clip was removed and how the shooting occurred, stressing that the incident was accidental, not intentional, and arose from reckless handling of a firearm during a tense moment. He highlights that the defendant immediately admitted responsibility, attempted to help the victim, and remained cooperative with police, while the victim's family initially tried to shield her. Although the jury found her guilty, they chose probation rather than prison, suggesting they viewed the case as a tragic mistake rather than malicious intent. The attorney underscores that she has fully complied with every probation requirement, completing classes, community service, and payments while maintaining employment and raising her children responsibly. He argues that her consistent behavior demonstrates rehabilitation and accountability, making her a strong candidate for early termination. Despite the state's position that the seriousness of the offense and the jury's maximum probation term should weigh against shortening her sentence,